Dream love until then.
Great. Well, thank you all so much and welcome to today's We Got This WA webinar series with the Seattle Metro Chamber. Really appreciate you all being here. I'm the Chamber's SVP of Operations, and I am also really excited for what our speakers have planned to tell us today about our COVID-19 Lease Amendment Toolkit talk. So wanted to start with first thanking our event partner, the Business Health Trust. They make it possible for us to be able to put on these great events. So big thanks to the Business Health Trust. A few webinar logistics before we get started. If you do need help during the webinar, please use the chat function. Lee is staffing this webinar and she will be able to help you with any sort of technical difficulties you may be having, and she'll assist you with that. If you have a question for our speakers, please use the Q&A feature rather than the chat. It helps us keep track of those questions a little bit easier. And wanted to also note that our speakers really want to tailor this experience and really want to get questions answered during the next hour. So we really encourage you to use that Q&A feature if you have any questions as they come up during the webinar, so that our speakers can adjust if needed and make sure to get those questions answered. And then the next thing is we are going to be recording the webinar and posting the recording on our website later today. So if you want to take notes but miss something, don't worry, it'll be available. If you want to share it with any of your colleagues after the fact, you'll be able to do that. So with no further ado, I'd like to move to introducing our first speaker, Jody Nishioka from Communities Rise. Jody has worked for over 20 years on behalf of low-income communities, particularly women, children, and immigrant and refugee communities. At Communities Rise, her team works to create an equitable system by pursuing cross-sector collaboration and providing capacity building and legal services for community organizations and micro enterprises. So Jody, I invite you to turn your video on and I will pass it over to you for your presentation. Oh, we might need to unmute you. There we go.
About that. Welcome, everyone. Thank you so much, Jane and the Chamber. Really happy to partner with you to put on this webinar. I also want to thank the folks, the speakers to come, who are our incredible volunteer attorneys from Perkins Coie. We'll be introducing them, but Nathan Farr, Aaron Holloway, and Jessica Cohen. They have worked on the materials that they'll be presenting on, and also have been presenting on the materials as they will be today. And we're really grateful for their service and their work on this. I just want to speak really quickly about how this all came about. Today we're talking about commercial lease amendments during this COVID-19 period. And I'm not going to talk about the substantive part, because I'm leaving that up to the lawyers. But it came about because, as we know, during the shutdown, you know, there's a decrease in revenue. People are having difficulty covering their rent and their commercial lease rent. And we've had moratoriums on evictions. And so it's creating a lot of questions in a situation where commercial small businesses are in a place where they need to renegotiate their leases with their landlords. And that's what we're talking about today. And that came about, we created this toolkit because I just want to thank the City of Seattle Office of Economic Development and partnered with us to create this toolkit. And then we, in partnership with our Perkins Coie volunteers, created it. So just wanted to thank the City of Seattle Office of Economic Development as well for helping us bring this lease amendment toolkit to fruition. All right, so can move on to the next slide. So Communities Rise, as Jane mentioned, offers a variety of services to the communities, including free legal services to small businesses and nonprofits. As part of those services, so you can apply as small businesses to our, for any type of business legal services. We have clinics where we provide 1 hour free consultations. It's sort of a one-time, if you have some specific questions you need, we have it either for COVID-19 questions or other business legal questions. And then we also provide longer term legal services on particular business matters. So if you need a contract drafted and it's going to take more than a 1-hour clinic services session, or a lease negotiated that's going to take longer than a 1-hour session, you can call us to get that sort of help as well. Today, I want to really highlight our COVID-19 Small Business and Nonprofit Legal Clinic. It's a new clinic that we created back in April to help get relatively quick turnaround to get you scheduled and in to talk to an attorney by phone or video. And so that's available to you for any of your small business questions that have come out of COVID-19. So the clinic is open to small businesses, nonprofits with 50 or less employees. You have to have been hurt by COVID-19 pandemic, which many of you are, and have annual revenues of less than $2 million, which is a really high number, but most of our clients are really a lot smaller than that. But there are a few businesses that have had annual revenues of 2 million and have been significantly reduced because of COVID. And finally, we ask you to state why you can't afford legal services. So we are a nonprofit. We use volunteer attorneys, and our purpose is really to support small businesses and nonprofits who cannot afford legal services. So if you can afford your own attorneys, we ask you to go ahead and hire your own attorneys. But if you can't afford legal services, that's what we're here for. Go to the next slide. So what kind of help do we help businesses with? In light of this COVID period, we're helping folks get access to the CARES Act and Families First Act loan and grant program. So that's the PPP and EIDL. And just FYI, the PPP has been extended to August 8th or 6th. I'm forgetting. August 8th or 6th, you can still apply for PPP loans. So they are still available. And then we are moving into the forgiveness period as well. So we can help folks understand what those processes are. Employment law questions, we're getting a lot of those types of questions. Commercial leases, which we're going to talk about today. Insurance and risk, contracts, folks are not able to perform on contracts that they signed, or they want someone to perform and they can't perform, the other party can't perform, so needing to amend those contracts. Unfortunately, some businesses are needing to close, so bankruptcies, business closure, dissolutions, general nonprofit governance stuff that's coming up, and just any other business legal questions related to COVID-19. That's what we're helping folks with through our COVID-19 legal clinic. Next slide, please. So how do you sign up for legal help? Well, we have an online intake form on our website. That's the link. If you go to just communities-rise.org and look at our legal resources page, our COVID-19 resources, you'll get to this link. It's an online form. You fill it out. It basically asks for contact information, how do we contact you, and then a little bit about your business or your nonprofit. And then once we get that into our database, it goes into our system, and you'll hear from us within a week. We have translated the intake form into Spanish and Chinese, and is now available on our website. We do provide translation for pretty much any language. So if you need a translation, or you know of someone who wants to access and they need translation, they just need to indicate that on the legal inquiry form or give us a call, and we can get a translator on the phone to do the intake, or in the legal services as well, we will have a translator. We'll match you with a volunteer attorney who has experience in the area you're looking for. And the lawyer will email you to schedule a time to talk, and then you schedule it with the lawyer at a time that's convenient to both of you. We expect it to take 4 to 7 days to get back to you with an attorney. Sometimes it takes a little bit longer, but we do get back to you to let you know that it can take a little longer. It depends on a variety of factors on how long it takes to find you an attorney, but we're trying to do it as quick as we can. Next slide. So we have other resources available, including our COVID-19 legal clinic, which again provides a free 60-minute consultation. We have some short instructional videos on the EIDL and PPP application. We also have some recorded webinars on the forgiveness process now. We have lots of written resources on a variety of topics around employment law, PPP loans, our lease amendment toolkit that you're going to be hearing about is also available. We also have some non-legal resources for nonprofits. I know this is a small business, so I won't get into all of those services. Yeah, we can move on to the next slide. I think that might be the last slide for me. Yeah, so that's our website, communities-rise.org. Feel free to go to our website and find a bunch of resources, as I mentioned. There's contact information if you have any questions about our legal services, and there is the intake form to get you legal services. And that's my presentation for today. I'm going to pass it on to, are we going back to you, Jane?
Yeah, I will just introduce the speakers. Thanks so much, Jody. It's really nice to have all of those resources in one place. I know there's so many COVID resources all over the place. It's really nice that they're consolidated and streamlined and put in one place for employers and organizations. So thank you for providing all of that info, and do want to now pass it over to, as Jody mentioned earlier, Jessica Cohen, Nathan Farr, and Aaron Holloway from Perkins Coie. And this is really that time for that Q&A box, so we will make sure to try to answer all of those questions. So Perkins Coie folks, I will pass it over to you if you want to bring up your videos and join us on sound.
Great, thanks, Jane. Can you hear me?
Yep, can do.
Wonderful. Hopefully Aaron and Jessica are able to start their videos as well. Welcome everyone. My name is Nathan Farr. I'm a partner with Perkins Coie in Perkins Coie's real estate department. And Jody, I want to thank you again for your very gracious introduction. It's been a pleasure to work with you and Communities Rise, and we look forward to continuing to do so for the foreseeable future while we all struggle through this pandemic. So thank you again for being such a fantastic partner. With respect to our presentation and the focus of it, Jody engaged with us I want to say probably 3 months ago, as this pandemic kind of took hold, and asked us to work with her in connection with some lease amendment and lease related documents that could serve the larger community, as again, everybody was grappling with the COVID-19 pandemic. So in conjunction with that, we worked with her, with our real estate team, to prepare a set of, call them template documents in the toolkit that tenants can use in a variety of circumstances, depending on where they are with respect to lease and lease negotiations with their landlords in particular. So that being said, let's go ahead, Jane, and switch to the next slide. And this is just our disclaimer about, the documents associated with the lease and lease toolkit, and our presentation today being just general advice and general counsel, nothing specific. And again, to the extent you need to discuss anything specifically with an attorney, I encourage you to contact Communities Rise. And I know personally, I've dealt with probably at least a dozen not-for-profit and small business clients in this pandemic to work with them in conjunction with their lease negotiations with their landlords. So please feel free to do that at your convenience. Let's go ahead and go to the next slide. Generally, what we'd like to cover in this slide is the current governmental orders imposed not only by Governor Inslee on the state of Washington, but also the Seattle orders that are in place and issued by Mayor Durkan. They do treat landlord-tenant relations and tenancies a bit differently, with Seattle offering much broader and tighter protections for small businesses and not-for-profits. That order, at least to my knowledge, is set to expire still on August 1st, so everybody is kind of holding their breath, trying to figure out what's going to happen between now and then thereafter. So we'll talk about, again, the current orders in place, the general importance of maintaining communications with various counterparties throughout this process, meaning to the extent any one individual tenant's business has been impacted by COVID-19, and most businesses have in some way, shape, or form or another, it's very important to, in our view and our experience, to reach out to your landlords. To the extent you've got lenders involved with your business, also communicate with them about what's going on, about how you've been impacted. Nobody can make an evaluation of any one particular tenant circumstance without having just at the very least open communications and understanding the impact of COVID-19 and the pandemic on that particular tenant's business. Then we'll talk about, again, some of the lease-related documents that we've worked with Jody to create. And we can talk, again, very high level about those and their application in particular circumstances for usage. And I think broadly speaking, that's generally it. I think our presentation should take about 10 to 15 minutes. Should be very straightforward. Let's go ahead and go to the next slide. With this, I think I'd like to bring Jessica Cohen online, if that's possible. Jessica, are you here with us?
Yep, I'm here. Hi,
Perfect.
everyone.
I'm going to turn over the next few slides to Jessica. Jessica's fantastic. She's an associate in our group, and she's worked very closely with us, not only on the presentation materials, but also on the lease documents and the leasing toolkit. So Jessica, with that, I will turn it over to you.
Thanks, Nathan, and thanks for having us. So the next several slides kind of walk us through the various, governmental orders that are in existence, and they're changing so frequently. This slide is about the state's order, the state's proclamation, which just as of last Friday, July 24th, had been amended again to extend the protections through October 15th. This is for those who want to read it in depth, Proclamation 20-19.3. Generally, his proclamation is about residential tenancies, and the goal is to protect people from losing their homes, losing their dwellings. Dwelling is defined quite broadly, to prevent homelessness, in the state. However, the proclamation does also cover on some commercial tenants, and back in April, it was expanded to also prohibit landlords from increasing rent or deposits. But this prohibition only applies if the tenant has actually been materially impacted from COVID. So the other aspect of this that's new as of Friday, the 24th, is the governor is going to try to put in place a working group of executive senior policy folks to meet by September 15th to discuss potentially authorizing increases. So we'll have to see in the next couple of months what happens with this prohibition against increasing rents or deposits for commercial units, and whether that's changed before October 15th. Next slide, please. Thank you. So now we're touching on Seattle, and Seattle's a bit, obviously a bit more liberal, and we have some broader protections. This slide focuses on the temporary moratorium issued by Mayor Jenny Durkin. It was recently extended. Again, it's going to set to expire by August 1st. Of course, that could change in the next day or two, but for now, it's set to expire by August 1st. This order does prohibit evictions for not paying rent for commercial tenants. So whereas the state is no evictions for residential, this is no evictions for small business. I should say not just commercial, but small business or nonprofits. Small businesses are defined as fewer than 50 or fewer employees per establishment. Her order also requires the landlords and the tenants to work together and to enter into payment plans to try to work together to actually make payments on their leases. Next slide. So actually, before we jump into this, there's also the City of Seattle ordinance from April 17th of this year for month-to-month commercial tenancies, the landlord cannot increase those month-to-month tenancies until the mayor's civil emergency is lifted. And for tenancies other than month-to-month, again, small businesses, rents cannot be increased unless the parties previously agreed to such increase in a lease amendment. You're also prohibited from renewing, again, unless agreed to, prohibited from renewing those leases if the rent is higher than it previously was. Also, the City of Seattle's ordinance, the small business is a little bit different from the mayor's in that, in addition to having 50 employees or fewer, the requirement is that the business had to be forced to close or had gross receipts from the prior month in 2020 less than 70% of the prior month in 2019. So the City of Seattle has, its ordinance has a little bit different of definitions in terms of who can qualify and who does not qualify. But we'll just have to keep our eyes, open in the next several days and weeks as these orders and proclamations have been changing really rapidly. This slide, the importance of communication, as Nathan mentioned, from the work we've been doing with Communities Rise and the various clients, it's really important to pick up the phone, talk to your landlord or your property manager, as I think a lot of issues can be resolved first just by discussing with the landlord. If you have subtenants, discussing with the subtenants. If you have a lender, discussing your payments with the lender. Next slide. I think I'll turn this over to Aaron.
Thank you, Jessica.
Sure.
Just want to address a question that just came in regarding so the question is, if it's only effective in Seattle for a few more days, then when will the mayor announce an extension if there is one? At this particular point, Jessica, I'm curious to your thoughts, but we don't have any particular insight as far as when or if Seattle will pass an extension. At this particular time, I know there's pressure from small businesses and other small businesses and tenants for the landlord to provide some type of extension or additional protections to commercial leases. But at this particular time, I don't think I have any particular insight if something will get passed or when it will get passed. I know there's a few days left before the August 1st moratorium is lifted. So I know there's pressure that's being placed on the city council, the mayor, to probably get some type of extension of some sort. But I have no particular insight as to when that will get passed, if anything will get passed, because there's equal pressure probably on landlords to have kind of a hard stop so they can, exercise some remedies on their end. So it's these competing priorities between landlords and tenants that the mayor and the city council have to make a decision on.
Yeah, that's right. And I'm looking at another comment or question. If my business is closed for a good portion of the year, is it untenable to pay? It's untenable to pay back rent. Will there be a government order allowing that lease to end without penalty? Well, I can't speak to what governmental orders may or may not come down in the future, but no, right now my understanding is there's not any kind of order that allows you to terminate the lease without any penalties, that the contract itself would still be in place and enforceable. Aaron, do you have anything to add to that question?
Yeah. So what I'm seeing so far in Seattle, Washington, and other jurisdictions around the country is that the protections I've seen so far is just a prohibition on evictions that says, look, if you're in default, monetary, non-monetary, that the landlord is prohibited from seeking to evict you from the premises. I haven't seen anyone go as far as saying that tenants have a right via some type of executive order to allow the tenant to terminate by some governmental right without penalty. So all that being said is that there's no executive order has been passed. However, as we'll get into as far as some of the things to communicate with your landlord about, in some events it's being negotiated. So that's something that it's on an individual case by case basis. But I have had tenants that's requested an early termination from landlords, and every property is different. If the landlord feel they can get a higher rent and they're still their space can still be marketed and they can find something, then some, or if the tenant is closer to expiration date already, you'll find some landlords may be open to an earlier termination with some type of termination fee, or maybe a partial forfeiture of some of the security deposit. So all these things are negotiable. But as far as any particular right given by, executive order from, city council, mayor, all the way up to the governor, I haven't seen any jurisdiction give that right without penalty, or just that right in general to terminate. So far, as far as I've seen, is just a prohibition on evictions. Let's make sure I answered everything. No, definitely appreciate the questions. Please keep them coming. We want to make sure we tailor this to specific questions as they come up, and then we'll continue to go through the slides. And if questions come up, we'll stop and we'll give your questions some attention and provide a response. So yes, part of the slides we're in. Yeah, so Jessica mentioned as far as communicating early, I just want to echo that. At this point, because there's no right of any sort that any government assistance is providing. At this point, what you can do, and the strongest thing you can do, is provide some type of communication of some sort. Sorry about that. That's my kids. Sorry, I know we're recording. The best thing you can do is to communicate, is try to get in front of your landlord and try to obviously be upfront if you haven't already. Be upfront of your scenario, your situation, and what things that you're going through, and trying to explain why you may need rent concessions, why you may need to terminate early. I found that it doesn't guarantee a certain result, but it will get in front of the landlord. You can explain your situation, be upfront about the challenges you're facing, whether it's less foot traffic, whether it's revenue, whether you're other type of costs and things of that nature. And seeing what you can work out. And that's been the best approach, as opposed to just kind of being on an island and silent, and, not discussing with the landlord, keeping them in the dark, and then, hoping something works out down the road. I just haven't seen that work out well. So it's a hard discussion, but it's a necessary discussion to have these type of open dialogue and communications with your landlord to see if you can work out some type of alternative arrangement. And most landlords, honestly, especially if it's in a multi-tenanted building, or if the landlord has other buildings in the city, they've already received these type of requests. So it's not something that they're surprised. They're anticipating it probably. So it's best to get out in front of it as early as possible. Okay, I have another question here. Besides the current issues revolving around COVID-19, there's a regional impact from the WSB closure, especially to SMB companies on the WS side of the bridge, or the west side of the bridge, excuse me. What resources are available either at the city level or for legal guidance on lease renegotiation amendments for not just COVID-19, but also the business impact from the bridge closure? That is something that will have consequences for businesses, even if and when COVID-19 edicts are lifted statewide. Jessica, you have any thoughts? I can give my thoughts on it, but
yeah, I don't know. We just I haven't been following any governmental orders or proclamations that are specific to the West Seattle Bridge closure. I know obviously that's having tremendous impact on folks, everyone, but especially folks in that area. But I've just been following really the COVID
Right.
specific orders. Aaron?
Yeah, I think it's uncertain. I think the priority has been just COVID-19, so that's been the top of folks' agenda, and trying to provide assistance from that, and so that may have taken a back seat, not too far in the back, but definitely a back seat to just the pandemic and things that trying to provide relief to both sides. Giving landlords some type of certainty that their contract is going to be upheld rather, and then some type of assurance to tenants that we're going to provide some assistance as much as we, from a state and city perspective, as much as possible to provide assistance, or at least some assurance that you won't be evicted and all the consequences that come with that. So from what I'm seeing, everything has been just dealing with the pandemic from a safety perspective and from a business and lease perspective, providing some type of assurance or at least some protections on both sides. So it's that juggling act. And the bridge closure has, at least from what I'm seeing in news reports and things of that nature, has taken a back seat. But I'm sure as folks start, making their concerns known, that will start to, creep up on a priority list to also make sure we're covering for that as well. Right. Another question. My lease has a requirement to be open during regular business hours. Can I be evicted for not being open, even if I pay rent? Jessica, curious your thoughts on this as well. So this will be most of what we're seeing is the failure to pay rent, which is a monetary default. This is a non-monetary default, as far as, well, technically, as far as you have some covenants in your lease to be open. I'm assuming this is some type of retail business, and there's some covenants to be open for certain hours. But your lease probably has some language that says that you have to comply with all laws, that all the obligations within the lease is subject to applicable laws. And if there's laws in place that you can only be open for a certain amount of time, obviously there's some type of tension here where, the lease says one thing, but applicable laws that you only have certain hours, especially for the safety of your employees and things of that nature. I haven't seen it, but I find it hard to believe that landlords are, I haven't seen it yet, that landlords are assuming or proceeding to evict, despite there's an eviction moratorium, things of that nature, for non-monetary covenant, a covenant breach, given the pandemic where we're in. I haven't seen that at all. So there's a line between, what the lease says and technically things of that nature, and what's practical, and what's more of a realistic approach, where landlord, and obviously every situation is different. So John, if you're having a specific situation where your landlord is putting pressure on you and making threats to evict you because of non-monetary breaches, definitely get in contact with the clinic and come to us, and we're happy to assist you with that if that's what you're seeing in your specific situation. But I haven't seen any landlord that are pursuing to not only claim you to be in default, but also take it a step further to to proceed to evict you because of something like that, especially given where we're in, where for safety reasons, for compliance with applicable laws, with our safety guidance, things of that nature, where they're looking to proceed with bringing an eviction action against you. I haven't seen that, but obviously every situation is different, and happy to have that conversation with you in the event that you're facing pressure from your landlord about this. Okay, where's part of the slides? Okay, so we talked about just having communications and things of that nature. As you're communicating with your landlord, one thing you want to know is your lease. Make sure you're up to date, up to speed with all the many lease provisions, lease obligations, both monetary and non-monetary, that's in your lease. So we put a few bullet points as far as things to be aware of. As far as high level, obviously every lease is different, so there may be some custom provisions that may not be included here. But some of the things that we have that you obviously should be aware of before and during your conversation with the landlord. Base rent's pretty self-explanatory. What's the fixed monthly rent? is usually a schedule of some sort that's in your rent. If you're a retail, things of that nature, or maybe a restaurant, then there may be a percentage rent provision that's in your lease where you're paying a certain percentage over some type of gross revenues threshold. So these are just base rent. The next prong is triple net payments, which is separate from base rent. So these may be payments depending on your lease, maybe additional amounts that you have to pay for insurance, some type of contribution towards taxes, utilities, CAM charges, common area charges, operating costs, things of that nature. So these are in addition to rent that you may be obligated to pay. Security deposit. Do you have a cash deposit up front with the landlord, a letter of credit? What scenarios can the landlord pull the security deposit? If they do pull the security deposit, at least a portion of it for any defaults, you have an obligation to replenish that security deposit. What timing considerations for you to replenish that security deposit? Just things to be aware of. And if there's any defaults that jeopardize any burn down provisions, which is a reduction in your security deposit, if there's no default, and you don't get the benefit of that because you're not able to pay or comply with all your obligations. The next thing to be aware of is any non-monetary obligations. One of the questions that were asked was covenants to be open for a certain period of time, or there may be other non-monetary obligations, maintenance, repair obligations, things of that nature that you may have to comply with even if you're not even open. You may have certain things you may have to keep up to date, HVAC, whatever it may be. There's certain non-monetary obligations in addition to the monetary obligations you have for rent and triple net payments. Consider if there's an earning guarantee. That usually be a separate document in addition to the lease, where you may have an individual or an entity that's backstopping the tenant's obligation under the lease. So if the tenant defaults, the landlord has the technical right to pursue the guarantor for any other losses or claims, things of that nature for the tenant's failure to comply under the lease. And then any default and remedy provisions. What's considered a default? What timing do you have before something escalates to an event of default? We have a couple more days before the eviction moratorium, but before the landlord can pursue those rights, they usually have to give you some type of notice and cure periods for you to rectify the situation to the extent that you can. Next slide, please. I will touch on this briefly because these questions typically come up as far as whether or not you are suspended or at least permitted to not perform under the lease based on certain theories. So force majeure is a contractual provision. Every lease is different. So definitely check your lease to make sure if you have this clause and this is embedded as far as any type of force majeure, which really excuses a particular party from performing. If some type of event, which is usually laid out in the lease, occurs, then you don't have to perform, or at least you're excused from performing. The tricky part with this is that usually there's some language that carves out that you still need to pay rent no matter what. So even if you may not have to comply with some of the non-monetary obligations, but rent still needs to be paid despite any type of force majeure. And the other issue is usually these force majeures, well, typically before COVID, these were usually kind of boilerplate provisions, which may not include any type of language towards a virus or a pandemic. So that may be silent towards whether a virus or pandemic is actually escalates to a force majeure, given that it may not be in your lease. So just take a look at it, make sure you're up to speed as far as what's covered in the force majeure and things of that nature. The other three bullets here are common law doctrines. I'll touch on it briefly. Impossibility and frustration of purpose. These are arguments that you can make by common law right that will further excuse you for performing if it's impossible for you to perform because of some unanticipated event, or frustrating a purpose that, look, is not impossible, but given the state of affairs and where things are and things that you could not have foreseen, it frustrated the ultimate purpose of why you entered into the document to begin with, the lease to begin with. Thus, you shouldn't be obligated to perform, given that the purpose of you entering into this agreement it has been nullified to some extent. I would tread cautiously with these two common law doctrines, just because, one, you need to go to court to even exercise these rights, which, for some folks, they may not have the funds to even take this that far. And then it's up to a judge to really decide, and that's kind of up in the air at this point. I have no clarity or any insight as far as what a judge or a court may accept, and I think that's still being ironed out at this point. Once folks start to bring this into litigation, so it's still an unknown at this point that I don't feel comfortable, giving any type of guidance or advice as far as the success of these arguments. If you find yourself in a litigation, so it's out there. It's something that folks have been mentioning just based on Google searches, but at this time, until the courts start to kind of, inhale some of these cases and really start to adjudicate some of these cases and where this stands, it's kind of hard to predict where the courts will end up as far as these two common law doctrines. Next slide, please. Actually, you know what? We kind of touched on this already. Can we go? I know we're running close on time. We can go to the next slide as far as concessions. Yeah, perfect. So what we're seeing in the market, as far as, we've had many folks, many tenants, and also landlords, but definitely a lot of tenants that has come to us a lot through Communities Rise and other clients we have across the firm, as far as what's market, what's being negotiated, and it's all on a case-by-case basis. Here are some things at a very extremely high level as far as things you can consider asking. But one caveat I would tell you is that, I wouldn't recommend any client to sign up for something just because the landlord offered it, if that's something that's not feasible for you. If it's not feasible, then you're just going to be right back into this kind of discussion down the road. And I'd rather you just be upfront rather than making promises for something that you can't keep up. So it's something for you to consider very, strongly with yourself and your partners, as far as what we think is a viable rent concession for us down the road, given that, is down the road is unknown for us. We don't know when the thing is going to end up, how much it will cost for us to, get up to speed with foot traffic and revenue, get back to pre-COVID levels. So it's a lot of unknowns. So before agreeing to any of these rent concessions, just, be honest as far as what you anticipate and whether or not you can comply with some of these, what you're agreeing to as far as rent concessions. But what we're seeing is the first point is rent abatement, where you're asking for a month or maybe 2 months, 3 months of abatement, which is just pretty much a waiver of rent for a certain period of time while you're going through kind of this period where, less or reduced or maybe no type of revenues. And you're asking for the landlord to kind of abate rent for a period of time until you can get back on your feet, or when you anticipate that rents will kind of start to escalate or increase. Another rent concession that we're seeing being negotiated is having, instead of rent abatement, which is abatement in full, you're asking for reduced rent, where I've seen some tenants have negotiated 50% rent for maybe a few months, and then it goes back to the regularly normal schedule that's in your lease as far as rent schedule. There's some levers to this. So it could be 50% reduction in rent from just base rent, your fixed rent, but you'll continue to pay the normal operating costs such as taxes, because the landlord is not getting a reduction in taxes, so they're passing that through to you. So taxes, the utilities, insurance, all those things you'll continue to pay at the normal level, but then the base rent gets reduced. These are all levers that you can all negotiate with your landlord. The third prong here is percentage rent. Obviously, this depends on your type of business. If you're retail, what I've seen negotiated, at least requested, is that tenants will say, look, I don't want to pay zero, whatever the fixed rent schedule, let's pretty much abate that fully and let's convert to a percentage rent, which basically means, look, if I make money, you make money, and we'll do this profit sharing for a particular period of time until we get to some type of level. Maybe, until we get back to whatever revenues was back in February or, January, December, whatever you negotiate. And then once revenue gets back to that level, then we can get back to the regularly scheduled fixed rent schedule. And then the other thing I've seen, which is not listed here, is just deferring rent, where abatement is complete rent waiver. Deferred is saying, look, the landlord's saying, look, I'm not waiving your rent, but I'm allowing you to push those 3 months or whatever you negotiate down the road. So if it's 3 months, you could say, look, you will amortize the 3 months rent over maybe a 12-month period. So, you know, if it, whatever the rent is, if it's $10,000 over 3 months, you can pay that back in addition to your regularly scheduled rent over the next 12 months. You'll add a little bit on to it to pay off the 3 months of deferred rent on top of that. Another thing I'm seeing is that instead of deferring rent, you may extend the lease for an additional 3 months at a higher rent down the road toward the end of your lease, to provide the landlord with more rental cash flows at a higher rent to offset some of the lost rent that they've lost based on any deferred rent or rent abatement that they provided you as a negotiated rent concession. So all that to say is that there's no right way to negotiate. It's all negotiable. It's all, you know, what you feel will get you through this hump, this period of time, which we hope is temporary. But all these things are negotiable. So I definitely highly advise, you know, to have these internal discussions amongst you and your partners, and, you know, figure out what would get us over the hump, where we're comfortable, where we feel we can be viable and survive, but also allow this understanding of the landlord's position that gets them some form of concession back to them where they feel comfortable. So it's really all partnership. We're all in this together, and hopefully the landlord's on board and on the same page with you as far as making this a viable partnership between landlord and tenant.
Aaron, I'm going to jump in and add that in the lease amendment toolkit that Jody spoke about online through that link, we have templates that have sample language going through these scenarios. So if you were going to enter into a lease amendment with your landlord, we have language that you could use to, you know, defer and amortize, or the percentage. So that's part of the lease amendment toolkit. We didn't put all of the documents here on the slide simply because it's too long, but you can see some of that language that Aaron was talking about on the website there.
Got it.
Probably the next slide.
Yeah, a few questions here.
Oh.
I think it's 2 questions. How will these impacts hopefully reduce rent going forward? Our lease is not up until November 2021. If we are likely to want smaller office space as more staff work remotely, any suggestions on how to move forward? Again, this is just a conversation with the landlord. It seems, I may be reading this wrong, but it seems like you may want to give back space to the landlord and have a smaller footprint, given that most of your employees and staff is working remotely. That's another rent concession that we didn't mention, but I think that's fair game, and I'm seeing tenants ask that from the landlord, to the extent space is available, can they get a smaller footprint and give back space? Essentially, is more like is giving back space, but you're kind of terminating the lease with respect to that space that you're giving back. Again, that's all negotiated, something with the landlord that you have to consider. But I think it's a fair ask, and to the extent space is available and the landlord can take your larger space and reconvert it and maybe find another tenant. But also, you know, if the landlord obviously values your tenancy and partnership, and wants you to be viable, then it's something that they have to strongly consider as well, putting you in another location. Continue the cash flow obviously is going to be reduced because you have a smaller footprint, but it's better than nothing for the landlord who may have an empty space available, and it allows that partnership to continue. So all negotiated options, where you just have to make the request and have those conversations. Definitely prefer phone conversations over email if you have to, or maybe do both at the same time, but having that personal touch has been more successful, at least in my experience, than written letters or emails. But it's a negotiated point where I think it's a fair ask. Let's see, here's
another question.
Yeah.
I can read this one.
Yep.
So this question is, I've sent emails and left voicemails regarding my situation, but I'm getting no response from my property manager. Is this lack of engagement common? any suggestions how to break through this apparent stonewalling or lack of urgency follow-up. Meanwhile, I continue to operate but have not been paying rent. Unfortunately, I have seen through some of the Communities Rise clients this scenario of property managers typically just not responding to the tenants. Before I saw the follow-up, I was going to say if you haven't been paying rent or if you're late on rent, typically that is, I don't know if it's a good way, but typically that's a way that the landlord would notice, or the property manager would notice and reach out. I guess I would say first look at your lease and see what sections of the lease, if any, talk about notice and notifying the landlord and the property manager. You may want to consider, a certified mail or a FedEx. But it's, in the cases I've seen, if the tenant is late on rent, that's kind of a wake-up call and the landlord will get back to the tenant. But in this case, I don't know, that you've been operating and continue to pay rent. Do you have you reach out to the landlord directly instead of going through the property manager?
Right, and Jessica, this is Nathan. I'd just like to chime in on that one particular point. With respect to official communications, yes, many landlords do have property managers, and most property managers are acting as the agent for the landlord. That being said, from a strict contractual perspective, the leases typically dictate how notices and the like are to be communicated. And to the extent you have official, I'll call official communications relating to your lease, to the payment of rent, etc. In our experience, the best practice would be to put together, prepare official communications to the landlord, potentially copying the property manager, but they wouldn't necessarily be directed to the property manager themselves for exactly this type of reason. That doesn't mean you're going to necessarily elicit a response from the landlord, but in, I think, every circumstance that I've been involved with, either the property managers are facilitators of communications, or they block the communications, or they don't facilitate them very well. So depending on which side of the fence that particular property manager is, and in your case, it looks like they're not terribly helpful, my recommendation would be to go direct to the landlord, potentially copy the property manager, but do the very best you can to get the landlord's attention. I think Jessica's point is correct. The non-payment of rent does typically get the attention of the landlord ultimately.
Do you want to go to the next slide?
Well, let's see. Do we have Jody, Leah? Do we have more time? I know you have some transition notes to exit, so I want to give you enough time for that.
I'm good. I don't need to say any more, except thanks to everyone. I do have to jump off soon, so you can go ahead. But thanks, everyone. Really appreciate all of you.
Thank you, Jody.
We don't have too much transitional, just about a minute or so you guys can continue for another couple minutes.
Okay, well, one other note I'd like to raise is, with respect to the cessation of the order, I've taken a look at the original order online, and in the original order in section 1, it does say that this particular order with respect to commercial evictions does, it says it lasts until March 3rd, 2020, or 60 days from the effective date of this emergency order. So I think there was a question that came online, right, as we've been discussing this presentation. It does say the decision to extend the moratorium shall be evaluated and determined by the mayor based on public health necessity. So I think, again, I would keep your eyes on the August 1st official kind of deadline where the moratorium itself is supposed to lapse, and see if it's officially extended. We can do some additional research, and to the extent we have some additional information, we'll try and pass that along regarding the quote unquote termination of the order.
I can take this slide on some other considerations. A lot of these Aaron touched on. I think one of the questions was about a breach of a non-monetary covenant of not being able to have your store or your business open. And I think this is an area where the force majeure concept may apply to the tenant's breach or non-performance of that obligation to stay open versus the monetary obligation to pay rent, which is typically independent, an independent obligation. The next bullet point and just other considerations is subtenants. If you do have subtenants and your subtenants unfortunately are not paying, you recognize that you as the tenant are ultimately responsible for their non-payment of rent. The next point is relief from business interruption insurance. If you do have business insurance, check to see if you do have business interruption rider. It solely depends on whether or not a pandemic, virus would be covered. Typically the ones I've seen, unfortunately, it's not, but we're just throwing that out there as another possible area of funds to talk to your insurance broker or look at your insurance packages and just see what you have. And then finally, just communicating if you do have a lender or any creditors, communicating with them. Obviously, they're aware too, but this is just impacting so many folks, and you don't want to be silent on that relationship either. Next slide. Oh, well, we've been having questions, but if there's more questions. And the final slide is really just a summary of what Jody talked about at the beginning. The bottom URL points you to where you can see this toolkit, where you can see all of these sample template documents. There's a lease amendment that has all of the rent options that Aaron went into, a sample lease termination agreement, and 2 different sample notices to your landlord if you need a good place to start. I think that's it. Anything else, Nathan, Aaron?
No, that's all I have.
No, and thanks everyone for joining the presentation today. Please do contact Communities Rise to the extent you have any follow-up questions or you're seeking additional materials to help navigate through these difficult times.
Great. Thank you so much, Aaron, Jessica, and Nathan. Really appreciate your time and work on this. I know that there's lots of questions and lots of specifics, and the toolkit, I went and checked it out during the webinar, and it looks like there's some really great templates and resources and things. So thank you all for all of your work on that. And I do want to just thank all of our attendees for joining us and for all of the great questions. We will, like I said, have this be recorded and on our website. So if there was any info in those slides that you want to capture and weren't able to, we do encourage you to do that. And we also encourage you to look at our events calendar for other We Got This WA webinars coming up to answer other tactical questions and things that have arisen due to COVID. So if there's nothing else from our speakers, thank you again. And thank you all to our attendees, and have a great day.
Thank you.
Bye.